Welcome back, everyone. This is Politics Tonight, and tonight we're focused on justice and politics in Nigeria, and I've been speaking with a legal practitioner, John Matthew. Mr. John, thank you so much for staying with us on the program. Now, the last governorship election in the state was very, very competitive. What made the difference between winning and losing?
Well, the last governorship election, I think, was one of the most debated in the country because of the interest that was shown. There you have, in the public domain, INEC displaying the total votes cast in the election that can be accessed by anybody, showing that the People's Democratic Party won the election. You have the same INEC declaring another person as having won. Contest went through the court system, and the facts are out there. In fact, quite recently, the candidate of the People's Democratic Party, who up till now as we speak, if you access the IREV and do the computation of the votes cast, you will know that that is the gentleman that won the election. On the 21st of this month, he took a trip back to his local government of domicile, that's at Akwanga, a distance of about 1 hour, 30 minutes from Abuja. The overwhelming crowd that came out to welcome that young man demonstrated quite clearly that this is the person that the people voted for. A journey of 1 hour, 30 minutes took over 7 hours, and an unprecedented crowd came out to welcome this young man. And I tell you what, even though the Supreme Court finally said it was the incumbent who won the election, the people who voted for him know the truth. They know the facts, and they came out en masse. And to demonstrate his credential as the people's choice, he initiated a program. Well, it wasn't a first time. It was a program that has been in existence before. But he enrolled about 13,000 residents of Nasarawa State into the National Health Insurance Scheme, where they will be able to access free medical care from that program. Now, this is a person who had just lost election, but this is what is giving back to the community. This is outside of the many laudable programs he has done before, which resulted in endearing him to the people. There's no electoral ward in Nasarawa State that you won't find his presence in respect of the boreholes that he had created.
Mr. Matthew, the SDP won 2 Senate seats in the National Assembly election. What made this particular contest unique?
Sorry, I beg your pardon?
The SDP won 2 Senate seats. The
Yes.
SDP, the Social Democratic Party, won 2 Senate seats in the National Assembly election. So I'm asking, what made this particular contest unique?
Well, what happened in respect of that election is protest votes. If you really want to understand which party was on the ground, look at the state assembly elections. Look at the state assembly elections. PDP, the People's Democratic, SDP that you're talking about, has only 2 members in the House of Assembly of 24. The People's Democratic Party has, I think, 9 or 10 out of the 24. So I don't think the fact that you had two members in the upper legislative chambers is indicative of the strength of the Social Democratic Party in Nasarawa State. The party on ground is the People's Democratic Party, and the facts and figures are there in the public domain to see. What happened with the senatorial election was the individual candidates, both of whom were old members, one-time members of the People's Democratic Party themselves, and it was their individual capacities that endeared them to the people who elected them. It's not a barometer to determine the strength of the People's Democratic Party in Nasarawa State.
Well, I'm sure your stance is quite debatable, because there are those who say you're speaking from the point of being the lawyer that represented the PDP. But then it would seem that the Supreme Court concurred with INEC. I mean, as a validated election of governors. Many believe that the court should not have the final say in our elections. Do you agree?
Well, whatever is created afterwards you will still have the same problem of people complaining one way or the other. I think what needs to change, really, is for us to take a hard look at our laws and where it is necessary to make adjustments to make. I, for one, as a lawyer, will want to see that the burden of establishing a credible election in an election petition tribunal should be shifted to INEC. They conducted the elections. They ought to come and justify why the election should stand, where a person petitions the election petition tribunal. Unless we have this shift of burden, with the current way our electoral jurisprudence is evolving, with the kind of decisions, very sorry decisions that are coming out of our courts, it will be difficult, if not impossible, for any petitioner to establish his case, particularly in a large election like a governorship contest. The reason being that some of the principles that are being established by the court do not stand to reason. I'll give you an example. Why will it be required of you, who has sued an adversary to court, to approach that adversary, to give you his evidence by way of a written deposition so that you can file along with your case against him before the case even goes to court? It's impossible. I'm suing you. You are holding something, some form of evidence that I need to establish my case, and the law is requiring that I should approach you even before I file my case to give me that evidence by way of a written deposition to file against you. Nobody does that. Nobody is simply impracticable. But that's what the Supreme Court is saying, that you cannot subpoena somebody to come and give evidence in court anymore unless you have previously filed that witness deposition against that person in court. So INEC gets away with all the shenanigans they do in elections. I'll give you a practical example of what I saw during these last electoral trials. We saw electoral forms, that is the form EC8 is that the polling unit results doctored and being tendered in court by INEC itself, in contradistinction to the results that were in IREF and the certified true copies which they themselves gave to adverse parties. It happened. Nobody is being held accountable. The various decisions that have upturned some of their declarations based on the figures that they produced. Now, who came up with those? Why were those figures changed? Nobody is being held accountable. So unless we enforce the laws we have on this accountability, and then we also do a readjustment of our laws to now turn the burden of establishing the due conduct of election on INEC, we will continue to run through the same cycle. And one would have expected that our Supreme Court should have risen beyond technicalities in deciding some of these electoral disputes. Because democracy will not make any meaning when you don't have a person who is duly elected in office on account of technicalities. That a court such as the Supreme Court, which is not only a court of law and justice, is also a policy court. And if democracy is about the rulership of majority, policy should dictate that whatever considerations are there, if there are hard facts showing that this is the person who won as opposed to this, the court should be bold enough to make those pronouncements. Otherwise, the impunity will continue, and every electoral cycle will only bring forth completely unacceptable results, and then the cycle continues. People become disillusioned with our electoral process.
Right. So I guess that's you reacting to the electoral verdict of the Supreme Court on the Nasarawa governorship poll. But earlier you talked about how a huge number of residents of Nasarawa State came out to welcome the PDP candidate, David Ombugadu. I'd like you to tell me, how loved is he?
Sorry, the last?
I said earlier you talked about... right, earlier you were talking to me about how huge number of residents came out to welcome the PDP candidate back into the state. So I'm asking, how loved is he in Nasarawa State?
Oh, I can tell you without any equivocation that David has done sufficiently to earn the love and trust of the majority of the people of Nasarawa State. If you saw the video clip of the people that turned out unsolicited on a working day, which I was informed was deliberately chosen so that we lessen the people who will come out to welcome the young man. If you saw the open affection that was shown, even during the contest, running through the courts from the declaration of the result up to the time the Supreme Court finally decided, you saw the protest by women, coming out openly to protest the rape. You note that the candidate has done sufficiently to warrant the love being shown. And it is not to be doubted, because this is a gentleman whom, right from his first tenure in the House of Representatives, took it upon himself to go beyond his federal constituency to sink boreholes to provide water for the communities across the state. All right. He took it upon himself to enroll quite a number of people in the National Health Insurance Scheme. He got employment for most residents across the state. So from the word go, he has demonstrated a capacity to provide service to the society. And it is in reciprocation that the love you see being displayed towards him.
Right. So earlier you were talking about whether or not we need to amend or review our Electoral Act. In what areas would you want to see improvement?
Well, first and foremost, I would like to see that the introduction of technology in the electoral process is strengthened with clear-cut guidelines about the mandatory nature of transmission of results in real time, so that sitting in your sitting room with access to your internet, you can do an arithmetic figure of the results as they come in. We need to do that. We need to strengthen our laws to make it mandatory, not optional, as part of the collation process. We also need to, at this stage, evolve to electronic voting. If there's sincerity of purpose, we're capable of doing so. We have shown in our association, Legal Practitioners, Nigerian Bar Association, we have demonstrated that in a smaller scale, that is achievable. Where our elections, we vote from your phone. Now, we can improve our electoral process to get to that level. It is only when people begin to have faith that their votes count, that there will be genuine participation and there will be respect for government that they were elected. And I had already earlier made suggestion that we need to upturn the burden of proof on INEC. Let them come to court to be the one to justify the due conduct of an election where a petitioner complains of undue conduct. So unless we do these things, we are not going to go anywhere. We'll continue to have the manipulation of the electoral process by people who have all the resources at their disposal. And lastly, I'd like to suggest too that it will be important for us to amend our laws to accommodate a conclusion of the electoral disputes before any party is sworn in, so that the undue advantage of the incumbency of office is not brought to bear in the dispute resolution mechanism, which, by the way, has taken a thorough beating in this last electoral cycle.
Mr. Matthew, your colleagues have also come on this program to say this is not practicable.
What is not practicable?
You just said that all of the election litigations should be concluded before swearing in of any political elected officer. So I'm saying that your colleagues have come on this show to also say this is not practicable.
I can't see how it's not practicable. It's just a question of adjusting the time the elections take place. We have put timelines on which we already have timelines in which the elections go through the court system. 180 days in the Tribunal of Trial, 60 days in the Appellate Court, and then 60 days in the Supreme Court. So if we adjust the timetable backwards to accommodate this time frame, definitely it's not impracticable. It's something that can be done. And if anybody who says to the contrary has to show how it's impracticable. It's just a question of adjusting the time. We hold elections earlier. We hold our elections earlier than the time frame. And that all it takes is to do a constitutional amendment.
All right, we'll see how that goes. The Supreme Court now has a full complement of justices. What is the implication of this?
Well, it is hoped that the backlog of cases that has piled up over the years can now be quickly resolved. It's a thing of concern that you have a case lingering for upwards of 10 to 15 years in the Supreme Court. This does not augur well for our justice delivery system. So now that we have a full complement of the court, I hope sincerely that they will attend to the cases, the backlog of cases expeditiously. If we have been able to manage and deal with the plethora of electoral disputes within time frames, I don't see how tasking themselves, they should not be able to do this. But I will go further to say that we also need to think with our Constitution to ensure that it is not every dispute that should go to the Supreme Court. For God's sake, a rent matter that starts from a district court has the capacity of traveling all the way to the Supreme Court. I don't think that is right. It is important for us to have some categories of cases that should be able to make their ways to the Supreme Court so that the Supreme Court lays down broad policy guidelines, lays down precedents which lower courts can now use in resolving disputes, which should end at those lower courts. If that is not practicable, it is also possible for us now to begin to consider regional Supreme Courts, where certain disputes must end at that level, so that we don't overclock the Supreme Court.
How can that be achieved?
It's done elsewhere in other jurisdictions. Take, for example, I'll give you an example. The National Assembly disputes, for example, now ends at the Court of Appeal level. So, if we have a constitutional amendment that says that, look, we're creating regional Supreme Courts at the maybe 6 geopolitical zones, that certain form of dispute only ends there. Once we have the law in place, it's not impracticable. Why should every dispute, every small dispute that starts from the court go up the way to the Supreme Court? You know, we only have one Supreme Court that sits in the federal capital here in Abuja. You can imagine if every litigant wants to contest his case up to the apex court, how many years it will take and the number of cases that will clock that court. So I think this is a time for us to really take a look at it, and so that our court can have enough time to consider deserving cases that are brought before them and give it the desired attention, so that the judgments we have there will have value and bearing on other cases.
In that regard, should there be a penalty for lawyers who bring cases termed as frivolous to the courts?
Oh, I think that's already been enforced. I have seen quite a number of instances where the Supreme Court, particularly, and even the Court of Appeal, has slammed sanctions on lawyers who have brought frivolous matters before them, matters they should know better not to bring. Quite recently, the Court of Appeal, I think in one matter where the PDP candidates, I think, who were removed by the Court of Appeal in Plateau, brought an application, I think, for judicial review. And the Court of Appeal slammed, I read in the news, about 8 million fine on each of about 16 of them. So I think it is important that where there's a clear case of abuse, where lawyers lend themselves to file matters they should know better, it is important that examples are set. But then it shouldn't be used as a means of dissuading genuine litigations where there's a need for one.
I mean, perhaps we need stiffer sanctions, because I remember about 800 out of 1,196 cases were dismissed in the 2023 election litigation cases. But then before we go tonight, the administration of justice in Nigeria, what are the issues and challenges in less than 2 minutes?
Well, I think one of the greatest challenge we have is the slow pace of the justice delivery system. We need to be able to relieve our judges of the need to write in longhand in proceedings in court. We also need to automate our courts so that the filing system is seamless, so that matters are filed quite expeditiously. Matters are determined quite expeditiously in automating court systems. And even the recruitment process, we need to take a very, very, very careful look at the recruitment of our judges. Recently, I noticed that in Kogi State, for example, the judges that were nominated for consideration, there was a pause to it by the NJC because people were nominating their cronies into judicial offices. So merit ought to be promoted more than anything else. If we do these things, we will enhance the quality of justice delivery system, and that will translate to a better administration of justice.
All right, thank you so much, Mr. John Matthew. I've been speaking with a legal practitioner as we focus on justice and politics in Nigeria. Thank you so much, sir, for joining us this evening, and I look forward to more conversations with you. Thank you so much. It's been a pleasure speaking with you.
My pleasure.